Well, good afternoon, folks. My name is Tom Martin. I am not Steve Sussman. As some of you may have heard, Steve was on his way here this morning from Las Vegas, Nevada, where he had a luncheon yesterday, and his plane was forced to land in Phoenix because it lost an engine. And as a result, he is not able to make the luncheon that he was so looking forward to attending today and visiting with you about. Steve and I have been friends for some time. We have made presentations here and there, and Hank, it's good to see you.
You too, Your Honor.
Thank you. Here and there, and I was coming down for the luncheon anyway and looking forward to just sitting back and listening to him. And he said, would you mind stepping up to the table while you're here? And so that's, you can all groan in disappointment because Steve is not here. I'm more disappointed than anybody. But it is a pleasure to be with you all today. Tim, I would like to thank you. Tim has been a friend for a number of years. Since he came on the bench, his in-laws, much longer than that. Judge Thompson and I go back to long before I was a judge. And I particularly like to thank Becky Miller, who was a juror in one of Judge Fryott's cases in January of this year, to talk about some things from a lawyer's perspective. I'd also like to, and I know Steve would insist that this be done and would do a much better job of it, but thanking everyone who co-sponsored the luncheon today, and for the folks here who put it all together. You're all extraordinary, and thank you so very much. Now, I do know that Steve had some comments, and he was kind enough to forward them to us. So what you're going to hear are largely Steve's words, but as interpreted. I'm kind of like the Bob Woodward book, I think, you know, in interpreting the comments that have been made. Tim, anything you want to say preliminarily?
The only thing I would add is that I think we all need to give a round of applause to Carmelita Shin, who has put all this stuff together for us, the logistics. Carmelita, of course, is our court clerk and does a fabulous job, so we appreciate her and her staff for bringing us all together today.
All right. Well, Steve Sussman is a remarkable person. Do any of you know him, or have any of you had professional dealings with him previously? Okay, well, I knew that Hank Meyer had, as a matter of fact, they've been panelists together a couple of programs. Steve is a native of Houston, Texas, and I'm going to give you a little background because I think it helps explain why he's in the middle of this project. Graduated from the University of Texas Law School, first in his class with the highest grades in the history of the school. He then clerked for a Fifth Circuit judge, and that's when the Fifth was included the 11th Circuit as well. And then clerked for Justice Hugo Black at the U.S. Supreme Court before returning to Houston to practice with the firm of Fulbright and Jaworski. After 7 years there, he decided to leave, and he thought he would go teach, and his wife, as he said, had other ideas about that, and thought that he needed to remain in the practice. So he ended up opening his own firm, which became Sussman Godfrey. He looked at practice areas that were promising and decided that antitrust and securities litigation were not well, or there weren't a lot of lawyers doing that kind of work across his part of the country. And it just happened that at about the time he was opening his firm, another young lawyer named Stephen Brill was getting out of the practice at Cravath and starting a legal newspaper called The American Lawyer. And Steve Brill was kind of interested in why someone would leave as a partner from Fulbright and Jaworski, and ended up doing a fairly significant article that brought Steve to the attention of a lot of folks. The practice flourished. He's a phenomenal lawyer. He's been at the forefront of a number of innovations to help streamline and economize civil litigation, including, I'm sure some of you have heard of the assessment agreements, and those were Steve's brainchild, where lawyers who are on opposite sides of cases actually contract with each other about the way they're going to resolve disputes without having to resort to filing motions and having hearings. They have been modified over the years, and Steve gives credit to another colleague of his for being involved in that process. But some years ago, he looked at the statistics on what's happening to civil jury trials, and he was somewhat appalled by the numbers, and we'll go through some of those in a short while. And he ended up funding a program through the New York University School of Law called the Civil Jury Trial Project. And he now says that he kind of regrets putting the word jury in there, because it happens bench trials are also on a similar steep decline. But he funded it to the tune of $2 or $3 million. He became the executive director, and he has been, in addition to his law practice now, holding luncheons across the country like this one to visit with lawyers. And the hope is, and we're very fortunate to have Ms. Miller with us today, to have jurors talk about their experiences on one or more juries, and to see if there are not some things that everyone could come up with that might bring back, to some extent, jury trials. He established the Civil Jury Project several years ago at NYU. It is the only academic center in the country that's devoted exclusively to studying why the jury trial was so important to our founding fathers, that it was mentioned in the Declaration of Independence, Article 3 of the Constitution, and in the Third Amendment to the Bill of Rights. Three of the Bill of Rights amendments. And civil cases was guaranteed by the constitutions of every state that joined the Union. The jury is so much a part of the architecture of the justice system that there's not a courtroom in the country that doesn't contain a jury box. And yet, could we go to slide 2 here? All right, thank you. Proves that those jury boxes today are largely unused. Since 1962, the number of jury trials conducted per the average authorized federal judgeship across the country has dropped from 10 trials to 2. And the average number of bench trials, as I noted a little bit earlier, has declined even more dramatically. And the decline of both bench and jury civil trials is pretty good proof that the disappearance of jury trials is not due to some special characteristic of jury trials, either their expense or their length, or the fear of runaway verdicts, or the requirement of specialized jury advocacy experience. Going to slide 3, and you might want to talk about this, Tim, since it relates specifically to Oklahoma and the Western District.
Sure, thanks, Tom. This indicates that looking at 2017, we had an average of 2.2 jury trials per authorized judgeship in the Western District, and then 0.7 bench trials. And lest you think that this is an incredibly low number, which it does seem like it is, these numbers rank us 24th in the country in the Western District for the number of trials conducted per judge, jury trials, and 18th with respect to bench trials. So Tom and I were talking before coming down here this afternoon, and you know, it does kind of go in fits and spurts. Sometimes you'll go on a run and as a judge, and you'll have a number of trials in a relatively short period of time, and then you have these droughts. I will tell you that I'm currently in a drought. It's been probably almost a year since I've had a jury trial, and I'm actively trying to try cases. I picked a jury for a colleague a couple of weeks ago, so I could get out of my office and into the courtroom. And I'm going to try a case for Judge Eaton starting next week on Tuesday, because he has 4 this month. So, it's kind of feast or famine, it seems. You either go a long stretch and not have any, or you just have a whole bunch at one time. But you can't disagree or argue with the overall average. And so that's the situation that we find ourselves in the Western District. And we'd like to try cases. I'd much rather be in the courtroom than sitting in my office pushing paper, even though that's necessary too. We do a lot of in-courtroom things that don't involve trials, of course, especially on the criminal side. But there's just nothing quite like handling a jury trial to make you feel like you're really doing the law. And so we all want to do that. I know I do. And I'm very interested in this project for that reason.
Carmelita, if we could go to the next slide. Some people say, well, not as many cases being filed, but if you look at the percentage of civil terminations by bench and jury trial, it establishes that it's been on the decline, notwithstanding the number of cases filed. And slide 5 shows the state court statistics. And they're apparently only disposing of about 1.5% of all of their cases by jury trial. The Civil Jury Project is studying why jury trials, and in fact all jury trials, are vanishing, whether that ought to be a cause for concern, and if so, what can be done to reverse the trend. And these are a few of the things that the Civil Jury Project has accomplished over the last 3 years. They've created and maintained 2 distinct websites. The Civil Jury Project.law.nyu.edu website is designed for lawyers and judges in general, and in particular, they have a group of judicial advisors, almost 200, academic advisors, they have about 65, and jury consultant advisors, and they have about 35 of those. And it's a place they can go to gain access to materials and information about what projects are going on. And with respect to projects, they have dozens. Their statuses are described on the website. They include engaging in empirical research on a wide range of subjects, such as a survey of non-lawyers that demonstrate most people don't know that jury trials are disappearing, and if they did, they'd be very concerned about it. Second, a study of all material B2B contracts filed by public companies with the SEC that showed that 50% of them, 57%, do not contain a jury waiver or arbitration clause. Third, interviews with general counsel that are showing that they have a growing distaste for arbitration. Fourth, surveys of judges referencing their use of certain innovations. And fifth, tests of whether many trial innovations that they are promoting actually are working. The project's putting on programs around the country for lawyers and judges, and communicating through lunches like this and social media with former jurors to learn from their experiences. They're hosting full-day workshops at NYU for state and federal judges, 30 at each workshop, on how to improve jury selection, jury care and feeding, jury comprehension, and education of jury trial lawyers. They have held 3, 2 more are planned for October. This is the 19th Jury Improvement Luncheon, and initial lunches are planned this fall for Boise, Idaho, Miami, Florida, Los Angeles, California, Tucson, Arizona, Palm Beach, New York City, and Fort Lauderdale. For each of the last 24 months, the project has published a monthly newsletter that's distributed to lawyers and judges for whom the project has email addresses. If you're interested in them in the future, you will be receiving them because you've given us your email address. There probably is an unsubscribe button on there as well, but I encourage you all not to push that one. Slide 7 is a second website, WeThePeople, which is designed for people who have completed their jury service and for those who have been summoned but not yet reported. The project reaches discharged jurors by asking judges across the country to distribute to those jurors a business card inviting them to the site to essentially blog about their experiences. They've had hundreds of jurors visit the site and complete a questionnaire about what they liked or disliked. The project dispatches a videographer to get short video testimonials from those jurors that appear to be able to speak about the experience in a meaningful way. The testimonials are shown on the website to folks who have been summoned but not served. Many of them resort to Google to find out how to avoid serving. And you can take a look at slide 9 there. The project contacts those through social media, and when they come to their site, they're urged by former jurors and persuasive judges to report for what we all hope and have found is one of the most rewarding experiences of the person's lives. Our hope is that the efforts of the project to connect former jurors with prospective ones will improve the yield of jury summons, which, as about all of you know, is woefully low in most jurisdictions. Now, you should have at your table a one-page list of the reasons that the project has identified for the decline of jury trials. They have been divided so that lawyers, trial judges, and the project can't do anything about, and those that they can do something about. Steve indicates that they'd be most appreciative. You're considering them, suggesting any others, and letting the project know what you all think the project should be doing. The lists contain the project's email. Today, the focus is on how to improve the reliability of jury trials. There are clearly alternate ways of resolving disputes, the most prominent being confidential arbitration using private judges. But there is no alternate way of exposing ordinary citizens to how the legal system works or empowering them to play an important role as decision makers. Now, Ms. Miller is here with us to visit with us about how we can make jury service more enjoyable for those who serve and more trustworthy for the minority of persons who try and avoid juries. And those are not only persons trying to avoid jury service, but companies and other parties that want to avoid jury trials and have their cases decided by some alternative means. Ms. Miller, we're happy to have you here. You all know Judge Giusti. I've introduced myself. Are there any other judges who are here today? All right, well, I'm going to hand this over to you, Ms. Miller, and if you just start out by telling us a little bit about the case that you were on and how it appeared to you from the time that you arrived at the courthouse through at least jury selection.
And Becky, remember, we don't want to get into the details of your own deliberations in jury service or talk about names and parties and attorneys, but with those caveats, you could tell us a little bit about what you did when you were here, and it wasn't very long ago, right?
No, I actually served in January of this year. The case that I served on was about a 3-week trial, give or take the fact that there was a holiday in there and some other personal things that the plaintiff had to be off for. So it kind of made the trial a little long, but it was a civil case, and it was an individual that was suing a large entity and for wrongful acts committed against him, discrimination pretty much against him in the workforce. So it was very interesting. From the time that I got my notice that I needed to appear, of course, I'll be honest with you, the first time I got my notice, I was like, oh no, really? And I had just been on vacation from work and actually had come back for 1 day and then had to go to jury selection. And then of course I was selected and was gone for 3 weeks. So my boss was like, could you not just tell him you were, crazy or something? And I was like, well.
Becky, had you ever served before?
This is my first time to ever serve.
Okay.
So I
How
can't.
long did jury selection take?
I was only here for 1 day. So we actually, the jury selection actually went very quickly. I came in with a large number of people. There were several hundred of us probably. We went through the process and I thought it was very informative. We went into a courtroom and had a video and learned a little bit about the judicial system, and then were dismissed, and then they called us individually to different cases. I guess there was 4 or 5 that they were trying to select jury for that day. I actually went to the first one and was not selected, and so came back with the idea that, well, I probably get dismissed now, and they informed me that no, you're not. So then I went back that afternoon for the second case, which I was selected to serve. And I take my civic responsibility very seriously. I know there are others out there that probably don't as much, but so I kind of felt like it was an honor to actually get selected to be a juror. That meant that at least somebody trusted that I would make a good decision and have a good opinion and be able to decide this matter. I can't speak for everybody on the jury, but I know just from getting to know them over the 3-week period that they were actually felt the same way. So we were a little nervous at first. Of course, we're kind of out of our normal routine. I'm a nurse, so I know work in an emergency department. So you take me out of the emergency department and put me into a situation that I'm not that comfortable with. Of course, I'm going to be really nervous about that. So, but I felt like everyone here did an amazing job at helping us to be comfortable. Our trial actually started the next day, so we didn't even get a break. So we were told, well, be here at, 8:30 in the morning, we're starting at 9, and it's gonna be a long trial. He warned us that from the beginning. So get everything in order, and we'll see you in the morning.
Becky, were you all allowed to take notes during the trial?
We were actually allowed to take notes. The note-taking actually did two things. Number one, it kept my attention and helped me not to fall asleep. Because I will be honest, there are some parts of the trial that were extremely boring and, kind of lost me there for a while. And then the other thing is it actually gave me a chance to kind of go back and refresh myself on the testimony like from the previous day, and then when we went into deliberation, it helped to be able to go back and look at some of my notes. But I think probably, to be honest, the number one thing the note-taking did for me was help me to pay attention. So it's a good idea. If they'll allow the jury to take notes, I think it's a great idea for that reason.
Becky, when you say you were not picked for the first jury, were you simply never called up and questioned?
Right, I was never called up and questioned. I was left in the gallery and did not
Okay.
go on to the actual jury stand.
So you did actually get to see, though, the questioning of the prospective jurors.
Correct.
Who did most of that or all of it?
The judge, and both of the cases that I was actually picked to go and be part of the jury selection were by Judge Friot, is that how you say it? Friot. Judge Friot.
So the lawyers were never involved in asking the prospective jurors questions?
They did not ask any of the questions. It was strictly the judge, which actually made it feel a little bit more comfortable that we were not actually on the hot seat, so to say, that the attorneys were questioning and drilling us. So I'm sure that the questions were pretty standard, and I know that from both the morning and then that afternoon, they were a lot of the same questions.
And then in terms of what happens after the jury is selected, and you made the jury, did the lawyers then make their opening statements?
Not that day.
But the next day?
The next day, they did.
And then from the opening statements, you went into the presentation of witnesses and exhibits?
We did. And then it began, of course, with the plaintiff taking the stand first. And his testimony actually lasted about a day and a half. So he was on the stand for quite a while. And so that was a great move by the plaintiff, because it gave us an up close and personal feeling with the plaintiff, the attorneys for the plaintiff. That was great, because we kind of got to feel like we knew the person.
What was your trial schedule for the day? You said you reported at 8:30, trial started at 9.
Correct. The judge made it very clear that he was a very punctual person, and that he expected that we would be here and ready to start at 9 that morning.
Did you take a morning break?
We did. We usually started out, we had a morning break around 10:30. We broke for lunch at 12. We were back in the courtroom 1:15, I think. And then we took an afternoon break, and then we were recessed. And from what it was very ritualistic. I mean, you could guarantee that at 10:30 we were taking a break, even if it was right in the middle of questioning.
And what time did you finish each day then? 5 o'clock? or-
We were out by 5.
Okay.
So, I'm saying, like, we were released from the courthouse and back to get our personal belongings and go into our car at 5.
Were you told at the outset of the trial how long it was going to take to try the case, the number of days?
The judge did say it was going to be a long trial. He expected it to be about 2 to 2.5 weeks. Like I said, there were some setbacks, and then the holiday, and so it did end up taking a full 3 weeks. But we were prepared for that, though.
Were you allowed to discuss the case during the course of the trial with your fellow jurors, or were you instructed that you were not to do that?
We were instructed every time we took a break, every time we left for the day. We were afraid to even look at each other before we, and we certainly, when we went to get lunch, if we were in the presence of any of the attorneys, we never made eye contact, ever. So it was, but it was, I mean, it was good to be that way because, and I will be honest, the jurors that I served with, like I said, we took it very seriously. And nobody wanted to waste anybody's time by not following the rules.
How many jurors were there in your case?
I want to say started out that there was 10. And then, unfortunately, one of them got sick towards the very end. And so we ended the trial with 9.
Okay. And after the evidence was completed, did you receive instructions before the closing arguments?
We did. And in fact, we took lunch. We was close to lunch. And so he's like, we're not even going to start. I want you to come back with a clear mind and head to get these instructions. And it was a long process for the instructions to be read. There were quite a few instructions.
Did you each get a copy of the instructions?
We did.
And were you allowed to take notes on them?
I don't remember if we were told to take notes on the instructions, but we still had our notepad, so.
And then you heard the closing arguments.
And then we heard the closing arguments.
And how long did the jury deliberate?
We were in deliberation for about 1.5 days. So.
Did you ever request any readbacks of testimony?
No, actually they have amazing equipment here in this courthouse. So we were able to use all kinds of media to be able to go back and look at evidence and read. And from the notes that we had made, we knew what we wanted to go back and look at and read again. And so we did not have to have any readbacks or anything like that.
Carmelita, you're using eJuror here.
We are.
Okay. How long have you been using it?
I believe since, for probably close to 4 years.
Okay. How many of you here have not had an experience with eJuror? Quite a few of you. It appears this actually allows jurors to access electronically exhibits that were admitted into evidence and other items from the jury room without having to dig through a big stack of papers and so forth. And for those of you who have not used it, I assume that you train lawyers over here if they need it on how it all works and
We do, and we train judges as well. So not all the judges are using it, but.
Well, I was going to talk to you about that after the program.
But we would be more than happy for state court judges to come and look. I realize we have more money than the state does at present, but this really is a great system. The jurors find it very useful.
I will say it was very useful because if we had to sit down and look through every exhibit in the book and look through everything, we would have been here for days. I mean, honestly. So being able to look it up on the computer, do a search, look it up, get what we wanted to look at, we could blow it up, highlight, whatever we needed to do. And to allow everybody in the room to see it, we could discuss it openly, and so I highly recommend it. I really do.
Carmelita, what are the things that you found over a fairly extended period of time? Excuse me, I'm sorry, Becky.
Oh.
During your time on the jury, that if you were able to control things, you would have changed. Either in the way things are done in terms of the handling of the trial, what you think lawyers ought to know who, as they present cases to jurors, anything?
Get on with it. I mean, that's because I will be honest, there's a lot of information that was thrown at us, but a lot of it was really repetitive, over and over and over again. And there was some of it that we felt like was trying to be, lead us down a different pathway, not being able to pay attention to the facts that, or why we were here for the case to begin with. I mean, I know that you guys have to do your thing to be able to defend what you've done, but at the same time, we're here because we want to hear the case, make the decision, and then go on. And when we hear the same stuff over and over, I mean, one of the pieces of evidence, and I won't go into detail, but was over a trailer. A trailer. I had heard so much about a trailer that I never wanted to hear the word trailer ever again when I left the court. I didn't even want to look at a trailer. I didn't want to hear measurements of a trailer, nothing. So.
Becky, different judges do it differently, but at the start of the trial, did you get any instructions on the elements that the plaintiff was going to have to prove to establish the plaintiff's case, or elements of defenses that the defense was going to be required to carry?
I believe that we did. We got, a pretty set out, this is what you need to be listening for, this is what you don't need to really listen for. You're going to hear, and I remember him specifically saying, you are going to hear a lot of evidence that really doesn't necessarily pertain to why we're here. So you're going to need, but it's your job as a juror to figure out what you need and what you don't need.
Did it help you in your task by getting those elements up front, so that when you were listening to the evidence, you could identify, okay, I know that this is going to relate to an element that they have to prove?
Very much so, very much so. So I do recommend that. You have to remember that jurors are not versed at the law like attorneys and judges.
Well, some of us aren't either.
we watch TV court and stuff like that, but we don't really know. And so kind of gear it more to that level of understanding, to bring it down to a level where it's more on the layman's level and not so much of the big fancy lawyer talk.
Do any of you folks have any questions that you'd like to put to Becky at this point?
Yes, were the jury instructions important in your deliberations?
I did feel like the jury instructions were important in our deliberations. Like I said, the group that I was with, we took it very seriously. And for probably the first half of the day, before we even got into the bread and butter of the evidence, we deciphered or attempted to decipher the instructions. And so that we all had what we felt was a clear understanding of what was being asked of us. So we did spend the first half of the day actually looking at that before we even started looking at the rest of the case.
Becky, did the jury ever submit any questions to the judge with respect to needing clarification about a jury instruction?
No, we did not feel like we needed any clarification. He made it pretty clear. Some of the instructions, I will be honest with you, again, has a lot of the legal jargon in it, and so it is kind of difficult to understand from a layman's perspective. So if I could say any kind of improvement that would be made, if at all possible, would be to simplify jury instructions so that it's easier for us to understand exactly what we're supposed to be looking at.
When lawyers would make, I assume lawyers made objections sometimes during the trial. Did that offend juror? Does it make you think they're trying to hide something by objecting to something? Or do you have any thoughts on hearing lawyers make objections during a trial?
No, I personally didn't, because I felt like it was, you know, the objections that they made seemed pretty logical to me. It didn't seem like a lot of unnecessary objections. And if there was questions, then they would, you know, go to the judge's desk and they would talk, and we realized that was probably they, you know, needed to sort some things out. So I didn't really take offense to any of that. Now, we didn't have a lot of it. I think that if you're objecting after everything that's said, that would probably get old pretty quick. So, yes, sir.
Was there anything that the lawyers themselves did that caused you to favor one side or the other? Just the way they presented their case, maybe arrogant, didn't like them, to where it kind of moved you to one side or the other?
Yeah, I mean, I wouldn't say persuaded me on my decision, but likability of yes, that did play a part. So, when you come across as arrogant, and I know this, and you're, you know, then that's gonna make the juror take offense, because we want to be respected as, you know, educated people that can make a decision, because obviously we're here because somebody thought we were smart enough to be here. So don't come across as arrogant, because it could, like, personally, it didn't sway my decision, but I could see where it could in some instances.
Now, Keith, if you get another letter from me inviting you to serve, what would you do?
I'd probably say, oh, no. No, honestly, I felt like it was an honor and a privilege to be able to come and serve and be a part of the process. I have a great respect for the law, and it was, like I said, it was an honor. That's why one of the reasons that I chose to come today is because I felt like it was an honor to be able to be chosen and to be able to serve. Of course, after the court case was over and everything, then you have it in your mind, did I make the right decision? Did I do the right thing? You know, and so, at least for me, I was constantly rethinking that, and actually went to lunch. I made friends with one of the other jurors, went to lunch with her, and we both realized that we did the right thing, so.
I think there was another question.
Question for you. Since you served on the jury and the case closed, did you go back after the fact and try to look up the case?
Absolutely, I did. I wanted to find out some of the other information that I didn't get told in this case. It was a very interesting case. And so, yes, I did. And because I had never heard of it before, which was great. But yeah, it did pique my interest, and I'll be honest, I did go back and look at stuff whenever everything was said and done. But it was not until after it was closed, because I didn't even watch TV. I was scared to death to watch TV, just because I wanted to make the best decision that I could.
There was a question over here. Over here first, and then we'll come over here.
With the presentation of the evidence, was there anything that you liked or didn't like about any of that? You know, highlighting or arrows or whatever, any of the way it was presented?
I like the fact that whenever it was highlighted and kind of directed my attention to what they were wanting me to read. I didn't mean that I didn't go back and look at the other parts of it, because I wanted to make sure I was getting the whole picture, not just that one little section. But it did help me to see the points that they were highlighting, to kind of direct my attention there.
Would there have been any part of it you would have changed that maybe comes to mind?
Not that I can really think of. I mean, like I said, the system that they have here, even when they pull the evidence up on and I don't know how it is in other courthouses because I've never served before, but they had the TV screen right in front of us in the jury box, and being able to sit there and look at it right there, that was very helpful.
Right here.
I had a follow-on question to the previous question. So after you went back and looked at the information, at the conclusion of the case, did you feel any differently about your verdict?
No, absolutely not. It actually confirmed my initial feelings that I've actually made the right decision, or we made the right decision.
I have a question for, you're talking about when you're sitting in the jury box, in federal court at least, you've got that computer screen in front of you. Did you have difficulty when, say, documents were being pulled up and actually seeing, like, wording on it? I mean, or was it pretty accessible and viewable to you?
It's pretty accessible and viewable, and, you know, of course, you share a TV screen between the two, but we weren't afraid to pull it over and look at it if we needed to.
Can you
So,
zoom in on those? I've never actually seen.
I honestly can't remember.
The attorneys have to zoom in.
Oh, okay.
So you see what the attorney wants you to see, and they can zoom in, but back in the jury room, yes, you can zoom in on whatever you want.
Yeah, then we can go back and look at the entire document. So, you know, if it was presented to us and it was zoomed in, we'll make a note, look at, so that we can see what else we were missing, so.
Well, and I just want to follow up on that. Did you feel when an attorney would do a call out and you're only seeing a paragraph in a page perhaps, did you feel that raised some suspicion that there might be something else that you're intentionally not being shown?
Well, yeah, it did. Honestly, I felt like, well, they're leading me this way, but I have to think, okay, they're leading me this way because this is the way that side wants me to go. But to be able to make the best informed decision, I really need to go back and look at everything and take it into the correct context.
Yes.
You seem very conscientious. I mean, you're the juror we all want, right? So thank you for your service. My question is, did you feel like you were more conscientious on your panel? Were there others that were not as interested in, you know, looking at the whole document and knowing what the full context was? Because certainly from our perspective, I think our fear is that we don't get a jury full of Beckys. We get other people.
Right.
So what was your experience with your other jurors?
We had a few other jurors that seemed like I will be honest, I was very lucky with the people that were selected. First of all, we all had pretty high educational backgrounds, and so we were actually able to deliberate at a high level. We did have a couple that were not at that same level that I think that they lost interest in the case because they simply didn't understand the lingo, the language. And so we were able to take them and break it down to them in a more layman's terms. And actually, the one that was having difficulty with the lingo he was able to explain to us the whole measurement of the trailer situation and why it was so important to him. So he actually helped us too. So I think that, like I said, the group that I served with, we were all very conscientious. We took it seriously. And we deliberated. It was split. I mean, it was not split as far as what the decision was going to be necessarily, but it was split on the monetary part that we were going to award. And that was probably the biggest hang-up, was deciding how much. And so we were pretty well split. And so the foreman led one side and I led the other side. And so we had to kind of meet in the middle, so to say. So, yes.
You talked a little bit about some things being repetitive. Was there anything else that you felt the lawyers could have done to have sped up the trial that you or some of your fellow jurors may have thought was a waste of your time?
Yes, actually, it did seem that sometimes that the attorney was not completely prepared with the line of questioning at that particular moment, and would have to pause and then so I felt like here I'm sitting here with my time. My time is valuable, and I would expect that if you were the attorney that's getting paid for someone, whether it's the plaintiff or the defendant, that that you would be ready to go and that you would not have to, look like you're lost. And then there was trouble sometimes with them finding exhibits or finding evidence, and we would have to wait for long pauses for that information. And I just would ask that if you expect for a juror to pay attention to what you're saying, you have to be prepared and you have to be Johnny on the spot with that information. I know sometimes there's gonna be glitches, but this was a pretty repetitive thing that happened in our case. Yes.
Did you feel like that impacted the credibility of the attorney who's feeding you the information? I mean, did that affect your overall impression of the case, seeing those repeated hang-ups?
I think it probably did affect it a little bit. To be honest, I thought they're not as prepared as the other team is. So it probably did affect it a little bit.
Can you tell us how you and your fellow jurors went about selecting a foreman?
We all pretty much sat down and said, who wants to be the foreman? A couple of us raised our hand, and then we did a vote between those people. So some people wanted to exclude themselves and some people didn't, and so we did a vote, and a pretty much popular vote.
Okay.
And it just so happened to be that it was very good. The seating situation was actually very good for the person to be the foreman, so. Yes.
Were there so-called expert witnesses in your case, and if so, were they helpful, or did you think they were bought and paid for, or how did that play out?
No, there were expert witnesses in our case, and I did not feel like they were bought and paid for. I felt like they, they gave their testimony and their side of it, and it was still our decision and up to us to decide what we actually believed was the correct thing. But I never got the feeling that they were bought and paid for. So I could see that if it was repeatedly over and over and over and over expert witnesses, that might be the perception of some jurors. So you go ahead.
Were there any demonstrative aids used in your trial, maybe a little model of a trailer? And if they were they helpful? Or if they weren't, do you wish they were used?
No, there wasn't really anything. They started out the very first day with a big board and wrote something on it, and then I thought, okay, this is gonna mean something. And then the board went through the back of the courtroom and never came out again. So I don't know what the whole point of that was, but there really wasn't anything like that, no.
Do you wish there were any demonstrative aids, maybe some kind of charts or?
I think in this situation of this particular case, that it really wasn't necessary at that point. So they did show some photographs and things that were in, but not on a board, it was on our screen, and they were helpful.
About right back here.
A lot of times, lawyers aren't allowed to interview the jurors after we try a case. In your situation, did Judge Fried allow the attorneys who tried the case before that you decided, allowed to interview you all so that you could answer questions they may have had after your trial?
No, he did not. But what he did do for us, and I recommend this highly because it was a great learning experience and it was great juror experience, is he actually, once we were excused from the juror, after the decision was made and read final, we left first, and he had us taken around to his judge's chambers. And we actually were able to sit down in his chambers and have a round table discussion. And that's when we were able to ask all kinds of questions, anything that we wanted. Why did they do this? Why did they do, why, a lot of why questions. And he was able to kind of explain those because the trial was over at that point.
But the lawyers were excluded from
The
that?
lawyers were excluded from that.
Okay.
I might add here that it's my practice also to meet with every jury after they're discharged, immediately following the case. And I asked the jurors to pass on to me any constructive criticism they might have for the lawyers. And then immediately after that meeting, which usually takes about 30 minutes, I meet with the lawyers and I pass on to the lawyers the constructive criticism that the jurors have for them. And then I pass on some of my own if they want to hear it. And so that's a common practice, at least in my court.
Excellent.
Everybody, I think, has their own way. I let the lawyers meet with the jurors and talk with them immediately after the verdict. I don't make the jurors meet with the lawyers, I give them the option, but most of them are interested in asking some questions as well as to offering some feedback on the trial. And I allow them to do it then and then, not at any time afterwards, but we either do it in the jury room or in the courtroom or wherever. I grew up practicing law in the state courts in Kansas before I was appointed to the federal bench, and we just routinely were allowed to visit with jurors afterwards, and I thought that it was the best learning experience that you could possibly have, short of just trying the case. I am interested in asking a few of you, because one of the things that Steve Sussman has really been stressing are things that we can do in trials to make it a better experience for jurors. And as an example, I have made lawyers in civil cases give complete opening statements before we ever begin jury selection. So they open to the entire veneer panel. My experience is that for people who are reporting for jury duty, particularly for the first time, there is that stress level when they're in there, and the longer that they're in the courtroom, the more relaxed they get and the more likely they are to be a little more open in responses. Second thing is, it actually, I found, shortens voir dire, because you don't have lawyers saying, well, we anticipate there will be evidence of this, and then objections because they're talking about evidence and so. And they've already heard what the cases are about. It tends to dislodge memories. You get far better responses to voir dire questions. I do a standard voir dire, but then I let the lawyers ask questions. I think it's important for lawyers to have the opportunity to question prospective jurors. And I really don't put too many limits on that. I just say don't cover the same ground I've taken, and ask for information that's going to allow you to make a determination about whether this is a lawyer or a person you want in your jury or not. You know, anybody knows to raise their hand. Will you be fair and impartial? Oh yeah. And will you wait to reach a decision until, yeah, I'll do that. I'll do all these things. And you're not getting any information from that at all, apart from the fact that people kind of know what's correct and when to raise their hands. And I think you ought to ask them about what they do with their time and how they spend it and how they feel about things. And then we go from, I give a complete set of instructions at the outset with a table of contents so the jurors have them throughout the trial. They're able to take notes on them, keep track of elements and all that kind of. I let them take notes, I let them ask questions. Probably the thing that's been most controversial until they've tried it is in civil cases, I let jurors talk about the case during recesses while the trial's going on. And I know that that is sacrilegious to some, and we've been trained, well, you know, tell them to wait until the end, and we instruct them that they're not to make decisions until they get to the end of it, because the case can turn on one question and one answer. The whole thing can turn around. But you know, we have had questions coming out of recesses, like we have a disagreement about what this witness said here, and it lets the lawyers clear that up right then. We don't have debates and we don't have readbacks about what the witness said. Anyway, we get to, if there are charges or claims that are dropped or dismissed over the course of the trial, it's a pretty easy matter of ripping out a page and substituting another one. And you tell the jurors at the outset that these may change over the course of the trial. But they know what the case is about going into it. They know what the proof is supposed to go to. If there is particularly complex testimony, I let the lawyers tell the jury before the witness begins, this is what we're attempting to prove with this witness. Or they can tell them afterwards, this is what we think we have proved with this witness. And to talk to jurors afterwards, they say it makes all the difference in the world in terms of their comprehension of what the case is about and what the evidence is. And the downside to all of this is the view is so different, as Tim can tell you, from this side of the bench as opposed to, and I spent a lot of years trying cases and sitting with people in both civil and criminal cases. We are solely interested in process on this side. The result of the case, if it's a well-tried case, it's probably going to turn out the way it's supposed to. And if you're shocked by the outcome, it may be an outlier, it may be you just misevaluated the case. It could be any number of things. But we want the process to be a good one. And if you have good lawyers doing their jobs, and by the way, Becky, the major complaint I get from jurors and talking to them afterwards is they must think we're stupid. You know, we get it the first time, we've sure got it the second time, but the third time we're insulted, you know, when they're beating us over the head with the same thing. But they loved the ability to talk about the case. They said it really took away the temptation to want to talk about it afterwards or at the end of the day. You know, they don't have to be tight-lipped. The only restriction is they all 12, and I've gone back to 12-person juries in civil cases. I just think they're better. All 12 of them have to be present and able to participate. If anybody uses the restroom, it's got to stop until they're back. But they found that hugely helpful. We've not had a single request for a read back in any trial that we've had, because I think everybody pretty well has determined, you know, not what the decision ought to be, but at least what the evidence is to date. Yes.
Have you found that shortens deliberation time?
Yes.
once the case is over?
Yes, it does.
Judge Leonard used to do that with his civil cases as well. He would not let them meet during breaks, only at the end of the day, only for a max of 20 minutes, and they could only discuss the testimony that they heard that day. And sometimes they were in there for 20 minutes and I had to knock on the door and get them out, and sometimes they were in there for 5 minutes and gone. So, but they all, to a person, said it helped them. It shortened the deliberation time.
We have given questionnaires to jurors and to the lawyers following, and I had 4 civil trials within the space of a couple of months, just a few months ago. And to a person, they all liked it. And it was, they were not all defense or all plaintiffs. And some, you know, you could tell that they thought one way on this issue and this way on another. And the lawyers who were really skeptical, and by the way, I don't give them a choice. If you try a civil case in my court, then it's not because I'm dictatorial about this stuff, but the fact is, if we give people a choice on whether to do it or not, they're never going to be tried that way. Everybody's going to opt for the tried and true traditional way. And so when I sent word out to all the lawyers in our district that we were doing this, I said, this is not a request for critique. There will be plenty of time for that after we've had some experience with it. but it really has turned out to be quite a wonderful thing. At least one judge in my district asked a recent group of lawyers, do you want to try Tom Martin's rules, or you want to do them the usual way? And they unanimously said they wanted to do them the usual way, which I think just, proves my point. But I do hope in the District of Arizona and in the Arizona State Bar has been leaders in trying a lot of these things. Judge Leonard is the first judge that I was aware of outside of Arizona that was allowing deliberations. I've taken it a little further, but I thought it was tremendous that he was doing that. And I think it's all at least worth thinking about. And Becky, given some of these things that we're talking about here, do you think that it would have made the case easier for you to hear and to think about, where the focus is not on giving, well, you're obviously going to want to give the best side of the case that you can for your side, but when you end up with a bunch of rules that are designed to give the jury the most comprehensive, clearest view of what the evidence is in a case, do you think that would have been helpful?
I do think it would have been helpful, and I love the fact of being able to talk amongst your fellow jurors, and it would have decreased the temptation to want to discuss it outside of the courthouse, which did not happen, but it is a lot weighing on your mind when you leave that day, and you're having to keep all your thoughts to yourself and in your head. And I think just to take like the 20 minutes or the 30 minutes to let people sit and talk about it and then move on, that would be very helpful in that decision. As far as like being questioned by the attorneys following the court case, I had a lot of questions that I would have liked to have been able to have asked them. Like, why did you do that? So help me understand, because I don't think you realize that did not help you. But so there was a lot of questions that I would like to have been able to have asked the attorneys as well. I think making it a more interactive thing, even following the case, would help the juror to feel like they really did a good thing.
So we've got about 5 minutes, maybe 10 at the outset here left. So I'd just like to give everybody an opportunity to ask any questions that you have of any of us, or to share any thoughts that you have about this process and how to improve it before we adjourn. So any further questions?
While you're thinking about raising hands, there's one last thing I wanted to mention. The openings before voir dire. The people who are not called to the box, and this has nothing to do with the way the case turns out, but it has everything to do with attitudes toward jury service. We've questioned them, and they feel that they have participated in the case, that they have not sat there for several hours just listening to people asking and answering questions. They've paid a lot more attention during the voir dire process than what people typically do. I'm not recommending this for everybody, but I hope that you all will at least give it a thought and maybe raise the possibility of trying one or more of these things. Last question I always ask lawyers at a voir dire or an in limine conference is there anything you'd like to try to do differently during this trial than what you've done before? I think it's the only way that we grow and we get better at what we do. So just something to keep in mind, and I saw there's a question back here.
Yeah, I had a quick question for Becky. So you said in your case the jury was unanimous on liability, that you thought the defendant owed something. The question was how much. Do you think that you would have maybe had more, the defense would have had more credibility if they would have stipulated to liability and come in and said, look, we know we messed up here, we only dispute damages. 'Cause that's probably where they were before trial. And if the defense would have come in and done that, do you think that would have affected the damages that you gave the plaintiff in that scenario? It certainly would have shortened the trial. Would you have been like, okay, we like them better? So,
It probably would have, to be honest with you, if you had come to me and said, we messed up, we know we did, we just need your help to decide how much we should give, or how much, you know, I don't know if we would have given as much as what we gave. I don't know the answer to that for sure, but I would go more towards the fact that we probably wouldn't have awarded as much as what we did.
Yes.
I assume in your case that there were multiple claims, though, for liability. There wasn't just one cause of action that you had to determine. That you had to determine a number of things like possibly discrimination, wrongful termination, or retaliation. So it would have been hard for you all to sort through that, even if they said we're liable for everything.
Yeah, you're correct. There was about 5 different things that we started out with 5 defendants. And then it was ruled that 3 of them would not be, that case would be thrown out. The judge decided that the case would be thrown out. And so we went from 5 to 2 defendants. And in each one of the defendants, I believe there was 4 or 5 different questions that we had to answer and award monetary value for each of the questions. So that would have been a little bit more difficult in that situation versus if it was just a one, yeah.
for one cause of action.
Exactly.
Any other questions? Yes.
Becky, do you have any feedback about the jury verdict form? Was there anything about it that was confusing, too long, or too simplified?
No, I thought it was fine. I didn't have any problems. We didn't have any problems understanding the jury form. And so, you know, like I said, we had a pretty good group of people on my jury. I was very fortunate for that, so.
Ms. Miller, thank you, first of all, for being here. This has been super helpful. Did you feel like where the lawyers were maybe stumbling or not as smooth in their presentation of witnesses and exhibits, that it was nerves on the lawyer's part for lack of doing it frequently, or did it just seem like they're not prepared to be in the courtroom today?
It came across to us, or me, that they weren't prepared for being in the courtroom that day.
Any other questions? Last call. All right, Tom, do you want to wrap it up?
Well, I just, first of all, thank you all so much for allowing me to be an interloper with you all here today. And it's always a pleasure to be in the Western District, and I handled a few cases down here a few years ago. I don't recall seeing any of you at that time, but anyway, it's a pleasure. And again, Carmelita and Tim, thank you very, very much, and all the sponsors who contributed to the luncheon today. And Becky Miller, you are the star of the show, and we cannot thank you enough. So keep that website in mind. I think there are some cards and information on the table. Take them with you, and you know, I'm sure that we'll do another guess.
The one-page sheet that you all mentioned are not.
We did not get it, but we have sent an email, and if we have your email addresses, we can get it to you.
Fabulous.
And if not, we may post it on our webpage, so look for it there as well.
Anyway, thank you all for taking the time to be here today. I hope you're taking away something that's at least interesting, even if it's not helpful to you. And with that, we'll hope to maybe see you at a future lunch. Thank you.